All rise. The Court of Appeals First Department of Ohio is back in session. Please be seated.
Good morning. The second case on our docket this morning is C-24-0406, State versus Jamal Jewell. It's my understanding that counsel for appellant was unable to appear this morning, but we have counsel for the state here. Is that correct?
That's correct, Your Honor.
All right. Mr. Springman, we'll hear from you as to the state's position.
Okay. May it please the court. This was a murder case and fairly straightforward in the state's view. There were 4 assignments of error that were raised. The first assignment of error was that the defendant was not Mirandized because he was questioned while in prison. The context of that is Mr. Jewell was serving time on another offense at Ross Correctional Institution and actually summoned the police because he wanted to get his story out regarding some rumors he had heard regarding the murder of Mr. Hurd. So he actually invited them to Ross Correctional.
And counsel, it's my understanding under the case law that we still look at the totality of the circumstances for the interview, and that's one piece of it, certainly, that he initiated it. But
Yes, that's one piece, and then what they did at Ross Correctional is they put him in an office, and they had a conversation, and he provided some information to police. There was nothing coercive about that. He could leave that office at any time he wanted to. In fact, the officers, or Detective McNeil, testified that when they left Ross Correctional that day, they still did not consider Mr. Jewell to be a suspect in this crime. That wasn't until later.
And this interview was relatively short, if I'm remembering correctly.
An hour and 15 minutes, that's correct.
Okay.
Yeah,
And
the
at no
other-
time did
yes.
he suggest or indicate that he wanted to leave? There was,
Nothing. It was pretty much him talking and giving his version and trying to get out ahead of some of the rumors he had been hearing about the murder of Mr. Hurd. So that was interview number 1, and then we can segue to interview number 2 that occurred at Warren Correctional Institution. Again, that was only an hour and 30 minutes. At that interview, the police did Mirandize Mr. Jewell and then had a conversation.
And did
with
they
him.
go back, did the detectives go back on their own volition, or was this one again?
Again, he reached out multiple times to the point he was sort of pestering them, so they went up there and out of abundance of caution read the rights to Mr. Jewell, who then made some more statements regarding the offense. Some of those were inculpatory.
What was the difference between the first and second interviews with respect to why the detectives Mirandized him in the second and not the first?
Good question. It was their investigation. They started to talk to Alexis and Michael, who were 2 witnesses that testified on behalf of the state, and they began to get a different picture and believed that Mr. Jewell might have been involved, so they went and questioned him and made sure they Mirandized him out of an abundance of caution.
so they considered him a potential suspect at that point.
I'm going to say they did because they Mirandized him, and that was probably a good move, a precautionary move, because they were concerned that now he was with Alexis and Michael, who were implicating him, and he was on a videotape with the victim as well shortly before this murder occurred. So that information that police had, they were now pretty concerned that Mr. Jewell might be the one that was involved, and they Mirandized him at this interview. And again, there's nothing coercive about it. The totality of the circumstances of the test, and from all indications from the record, it was a very casual conversation. He never wanted to stop it. He never invoked any sort of Miranda rights at all during that interview. And that was about an hour and a half, maybe an hour and 35 minutes, if my math is correct. And again, it was a short interview. And some of that.
Can we infer from the totality of the circumstances here that he waived his Miranda rights? I mean, he executed the form, so he was aware of his rights, and he continued talking to officers under these circumstances.
He did, and he certainly waived. And then, I know it's controversial, but it is the law. Burgess versus Tompkins says there can be an implied waiver. So even if you don't affirmatively waive your rights to Miranda, they're still considered, if you talk to police and you were informed of those rights, that's still considered to be a waiver. So that's the law we operate under. I know it was a 5-4 decision, and not everyone agrees with it, but it is the law of the land. But I don't even think we get there.
He signed the,
He signed the waiver.
and
so I
that's
don't
another
think we get
factor
there.
to
That's-
consider.
Exactly. I don't even think we get there, but, that's sort of the wall there that protects us, but we don't even get there.
And he had prior convictions, right? I mean, he was serving time on another case, so there's some reason to think that he had an understanding of how rights waivers worked.
Right, exactly. And the other thing that the case law sort of points out too is if somebody's in prison and they're being questioned on an unrelated offense, it's not like it's the shock of just being arrested that might, embarrass them a little bit. And, the factor of him keep summoning and wanting to tell the side of the story is another factor, I would say, that shows there was not any intimidation, any inducements or promises that were made. In fact, Detective McNeil was very clear that he was not making any promises. He says, I'll tell the prosecutor's office, I'll tell the authorities what you told us, but I'm not making any promises. And that was
Wasn't he asking for case consideration? I mean, he was wanting a sentence reduction on his other case and things like this, so he was trying to broker a benefit for himself by speaking.
Yes, and he wouldn't have gotten any case consideration on the current case, so I think he wanted to get out in front of the story. That's kind of maybe drawing inferences, but that might be why he wanted to speak. But Detective McNeil is pretty experienced and was very careful to make sure that there wasn't any promises at all made to Mr. Jewell in these circumstances.
Doesn't that speak to some level of awareness of how participants in the legal system operate?
Yes, there's a lot of books been written about this because after Miranda, everyone was under the impression that no one would confess anymore. And the reason why that didn't happen is it seems like when someone is questioned by police, they play a cat and mouse game. They want to know what police might have, and so then they speak. At least that's, been written about a lot. And so that's why many waive Miranda and talk to the police.
And what about the jury admonishment in this case? I believe the trial court told the jury, and I'm paraphrasing, something like, don't talk about the case, in essence, like when they were leaving during breaks, but didn't read the full statutory provision about not forming an opinion and not seeking outside information and sort of the fullness of the instruction.
Yes, I'm a little surprised that was raised because there were more places in the record where that was read. It seemed like it was read at every break. Now, one thing was clear, and the most important part of that instruction was that the jurors do not consult with one another. And they were admonished on the very most important part of that instruction multiple times.
Where is that designated as the most important part of the instruction?
I guess that's me speaking, because when you're dealing with a jury, you want to make sure they don't discuss the case unless all of them are together as a body in the jury room.
But there's nothing that designates part of that admonishment as more important than the other.
I don't think so. I think it's important that that message be sent to the jury. There's no indication on this record that the jurors ever engaged in any misconduct, and they were fully aware of their duties not to discuss the case with each other. They did have the video that they were watched prior to their jury service that also gave them detailed instructions on how they are supposed to behave. And that with the court always admonishing, always reminding the jury, that they can't discuss the case with each other.
If we were to find that the trial court did not comply with the statute, what's the remedy? Is there a remedy?
Yeah, the remedy is, there's case law that suggests that that's not a reversible offense, so it has to be.
Would we
pretty
have to
egregious.
find juror misconduct?
You would have to find some kind of juror misconduct under the case law, some demonstrable juror misconduct on the record before that would even be reversible.
Thank you.
Then, moving on, there was an ineffective assistance of counsel claim raised, but I'm having trouble why. It's because defense counsel didn't raise a constitutional argument on the motion to suppress, but I can't really address it because I don't know which constitutional provision they are asking for, they wanted counsel to raise. It could just be that this was a real clean investigation and there wasn't a whole lot that could have been raised. And sometimes, as we know, failure to file a motion to suppress does not automatically result in ineffective assistance of counsel. If anything, this would be more for post-conviction for evidence outside the record because it's just a hard issue for us to address.
Well, I mean, defense counsel and your opposing counsel cited Morris.
Morris, right.
And it appeared to cite specifically the concurring opinion where
Yeah.
it encouraged people to talk about the state protections being greater than the federal. But
Right.
in Morris, the issue was that the defendant had counsel, but yet the police interviewed him anyway. That's not the case here. I mean,
No.
Mr. Jewell didn't have counsel.
No. This was, what happened in Morris occurred because under our pretrial system in Ohio, you get designated an attorney at the first appearance, which our local rules call arraignment, but it's first appearance, occurs within 24 hours after arrest. And so here, this occurred before Mr. Jewell was even charged. So the Morris case would be completely inapplicable to the facts of this case. The other thing too, the giving of a complicity instruction was another error, but here, there's statements that show that Mr. Jewell was a complicit. There's statements that show he was a principal offender and played a role in this.
Well, it was the state's theory all along, though, that he was the actual shooter, right?
Yeah, it was pretty much the theory, but, out of an abundance of caution, at the very least, if the jury didn't find that, he was acting in concert together with Alexis and Michael, so the brother and sister. So I think it was okay, and if anything, it was superfluous then, because we went above and beyond, and I think proved beyond a reasonable doubt he was the principal offender. He was the shooter.
And the statute would have permitted the jury to convict him under either a principal theory or a complicit theory.
Yes.
Does it matter if we know which?
No, the penalty is the same. So it doesn't matter. The principal offender or the complicit, the aider and abettor is punished the same as the principal offender under Ohio law.
Well, Mr. Jewell has raised a weight insufficiency challenge, and I think it's somewhat nonspecific as to which counts or exactly how he's posturing this challenge.
Right.
But one of the things he is saying is that there wasn't sufficient evidence as to complicity. But if the jury convicted him as a principal offender, then would it matter if there was insufficient evidence as to complicity?
No, I don't think so. Then it's just, again, superfluous and probably done in an abundance of caution. And I think the statute has been amended too, by the way, that you can be convicted solely on testimony of an accomplice. It's just that the jury has to be instructed to, given a cautionary instruction that they may have a motive behind their testimony.
Well,
So-
do we even have that here? I mean, you had the Mako receipt and the surveillance video and,
Right.
and Jules' own statements, right?
That's the corroborating evidence, so we don't even get there, but, yeah, it's, again, it's, like I said in the beginning, it's a pretty cleanly tried case. You know, I know Detective McNeil well, I'm sure the court's seen his work in other cases, and I think this was handled very carefully. And so I don't see any reason to reverse it, but I'll be glad to answer any questions.
Just one more question
Yeah.
about the manifest weight argument.
Yes, Your Honor.
The main thing that the appellant appears to be hanging his hat on are the inconsistencies in the testimony between the two siblings. Can you address that, please?
Sure, I will, Your Honor. The inconsistent testimony is always for the jury to determine who is telling the truth. And the law is that way because, as this court knows, you're reading the record of the testimony, and you don't get to observe the person and the different gestures they make, or maybe they're putting their head down, or maybe they're talking low. And you can just sort of tell by verbal cues that maybe they're not all that credible. So that's why the law is always that when there's inconsistent testimony, then an appellate court will take the evidence in the light most favorable to the prevailing party, which in this case would be the state. So that's the reason behind that rule. But again, if any more questions, I'll be glad to answer them.
Thank you.
Well, thank you. Thanks for listening to my arguments.
Thank you for your argument this morning. We will take the matter under submission and issue a timely decision. For the students in the room, please remain. We'll be back to join you in just a few minutes.